Some people call you the elite. I call you my base.
Comes the true story that will make your temperature rise.
In 2004, documentary film producer Michael Moore released his controversial documentary film, Fahrenheit 9/11. The film presented the events of September 11, 2001, from a perspective clearly unfavorable to then-President George W. Bush. Citizens United, a conservative nonprofit corporation, brought a complaint to the Federal Election Commission, arguing that the television advertisements for the film were political advertising and therefore subject to the restrictions of the Bipartisan Campaign Reform Act of 2002. The FEC decided that the rules did not apply to the bona fide productions of a film for commercial purposes.
I am sick and tired of people who say that if you debate...
So, Citizens United then began to produce its own documentary films, including a negative one on Hillary Clinton, then a senator and prospective presidential candidate. It was advertised and shown on demand on television. A federal district court found that the film was essentially a negative commercial against Clinton that violated the Bipartisan Campaign Reform Act. Citizens United appealed to the Supreme Court. The case was Citizens United versus Federal Election Commission.
Hi, I'm Doug Ginsburg, and I'm a federal judge. The case of Citizens United versus the Federal Election Commission was an important addition to the continuing national debate about money in politics. The 2002 Bipartisan Campaign Reform Act, also known as the McCain-Feingold Act, prohibited corporations and labor unions from electioneering communications, such as broadcast cable or satellite transmissions, within 30 days of a party convention or primary election, or within 60 days of a general election. It required the disclosure of its donors and a disclaimer in the communications themselves if they were not authorized by the candidate. In this 2009 case, Citizens United argued that these provisions of the Bipartisan Campaign Reform Act violated its First Amendment right to free speech. The First Amendment states that the Congress shall make no law abridging the freedom of speech. It does not say whether this freedom extends to corporations or other types of associations such as unions. Those in support of the Campaign Reform Act thought that money was having a corrupting influence in the electoral process. The key question was, do laws that limit a corporation's ability to spend money in order to influence an election violate the free speech clause of the First Amendment? Justice Anthony Kennedy, in his opinion for the court, reasoned that political speech is indispensable to a democracy, which is no less true because the speaker is a corporation rather than an individual. After oral arguments, the Supreme Court, in a 5-4 decision, sided with Citizens United with regard to the ban on corporate and union speech. Justice Kennedy wrote the opinion in which one other justice joined. 3 justices concurred with the result, but used different reasoning, and 4 justices dissented with regard to corporate and union speech. But 8 justices upheld the provision requiring the disclosure of the donors behind the advertisements. This ruling expanded the role for corporations and labor unions in the political process as long as they did not make contributions directly to or coordinate with a candidate. This made political action committees and so-called super PACs the preferred vehicle for donations because they do not coordinate with the candidate that they're supporting.
Citizens United versus Federal Election Commission was decided in favor of Citizens United by a 5-4 majority vote in 2010. The key principle was the First Amendment, freedom of speech. The court held that political spending by corporations, associations, and labor unions is a form of protected speech under the First Amendment.